You're tuned in to Agriculture Today, and on this Wednesday, we're joined with K-State and Washburn Law Professor Roger McEowen for an Ag Law Update. Roger, thanks for joining us today.
Good to be with you, Shelby.
Our Ag Law Update you wanted to talk about was the Sackett versus EPA case. Could you give us some background on what that is?
Well, this is a recent opinion of the U.S. Supreme Court. It came out on May 25, and this is a very important case for agriculture. In fact, it's one of a couple of cases in ag that we've been waiting for quite some time. But the Sacketts are from Idaho, and they bought property in that northern panhandle area of Idaho, just south of the Canadian border, near what's known as Priest Lake, a very beautiful area. Priest Lake is a navigable water of the United States for Clean Water Act purposes. There are lots about 150 yards away from Priest Lake. And so they were going to build their home there, so they started backfilling the lot with dirt to prepare to put their home on it. And EPA came in and said, no, you're going to have to stop. Your lot is a water of the United States, because it was near a ditch that fed into a creek that fed into Priest Lake. And so it became a navigable water of the United States by virtue of those connections to Priest Lake, which was and is a Clean Water Act jurisdictional lake. And so EPA threatened them with penalties of up to about $40,000 a day unless they stopped. And they just simply could not negotiate anything with EPA. EPA was belligerent. They wouldn't back off. Sacketts get backed into a corner, had to sue. They had no choice. And they actually made two trips to the U.S. Supreme Court. The first one was a unanimous decision by the U.S. Supreme Court to force EPA to make a final determination from which the Sacketts could appeal. EPA said, yeah, it's a wetland. So then the second trip around was challenging that wetland decision. And they lost in the trial court, lost in the Ninth Circuit. And just recently, the U.S. Supreme Court gave its opinion.
And kind of before we touch on what the Supreme Court decided, for the definition of a wetland, considering the swamp buster and portion of agriculture, is that definition a little different?
Yeah, that's a good question. That definition is indeed different, and that is a definition that requires three characteristics to have a wetland. You have to have hydrophytic plants, and you have to have soil hydrology that signifies that it's a wetland, and it has to be inundated for at least 14 days during the growing season. That's totally different definition of a wetland than is what is contained in the Clean Water Act for purposes of what the Sacketts were going through and jurisdiction by the EPA and the Corps.
What has the Supreme Court decided?
Well, the Supreme Court unanimously agreed that the Sacketts lot was not a wetland. So there was no jurisdiction under the Clean Water Act by the federal government. And so that's very important because all of the justices rejected the significant nexus test, which is what we've been using for the past almost 20 years in determining the scope and delineation of what a wetland is on farmland, for example, that's subject to the EPA or the Corps of Engineers regulatory authority. Now, that was 9-0. There were 5 justices that said that the correct test was a continuous surface water connection test. So this is the way that we now will determine whether you have a wetland subject to jurisdiction under the Clean Water Act on farmland. Is whether your wet area has a continuous surface connection to a navigable water of the United States. No longer are they going to try to connect things up by this ankle, knee, hip, elbow, wrist type connection. This is connected to that, that's connected to that, that's connected to that, and that is a navigable water. They're not going to do that anymore. They're basically going back to what I call the Justice Scalia standard that he set forth in another case in his plurality opinion in 2006 in that case. So the important point of this is for the government to assert jurisdiction, it has to establish two things. It has to show that the adjacent water body or this isolated wetland in a farm field is relatively permanent and is connected to an interstate navigable water, and that area, that wet area, has a continuous surface connection with the navigable water body that makes it difficult to determine where the navigable water body ends and the wetland begins. Now, there were 4 justices that said that's too narrow of a test, but again, that's just the minority, and that will not control. But this new surface water connection test is going to be the new rule going forward.
And so the surface water connection test was good in terms for Sacketts.
That's correct. Not only did they not have a wetland, but we got a much narrower definition of how we delineate a wetland for purposes of the Clean Water Act.
Roger, what does this mean for the EPA's 2023 WOTUS rule?
Well, it means that rule is deader than a doornail, so to speak. The court said it is inconsistent with the text and structure of the Clean Water Act, and the EPA has no statutory basis to impose a significant nexus test. That's pretty harsh language, and so they're going to have to redo that. And a lot of listeners are probably familiar with what I've been saying for some time. I thought it was foolish for the agencies to move forward with rulemaking before we knew what the U.S. Supreme Court was going to say on this issue. So now we know that was all a waste of time and a waste of money, and they're going to have to start over and write a new rule consistent with this continuous surface connection test.
And before we started, you mentioned an upcoming case. Is this going to create a positive impact, hopefully, for them?
Well, just a couple of weeks before the Supreme Court issued its opinion in Sackett, they had decided to take a case. They agreed to hear a case coming from the East Coast in a federal circuit court there involving a rule involving commercial fishermen. Now, that's the facts that are involved. The point of law that they're interested in is how much deference that the courts are to give to administrative agencies. And interestingly enough to me in Sackett, none of the 9 justices even talked about deference. They didn't say, well, we should defer to the agency. The agency has the experts on this, and under what we call the Chevron deference rule, we really should defer to them and determine whether their rule is just completely out of sync with what Congress intended, what the statute says. None of that. The court just said, no, this is not an area in which we're going to defer at all. They didn't even mention deference. They just decided the case. I think that's a tip-off as to where we're coming with the Loper-Bright decision, which will be next year in this commercial fishing case on agency deference. I think they're going to eliminate what we know as the Chevron deference rule. And
so what was the Chevron deference rule?
That's a rule where the court said a number of years ago in this famous case known as Chevron that in the way that courts judge whether an administrative agency rule is consistent with the statute, they basically will defer to the agency unless that rule is deemed to be arbitrary and capricious. And that's a very high hurdle for anyone challenging a federal government agency rule to overcome. And that's been a burden on farmers and ranchers for many, many years. You get into a dispute with USDA concerning farm programs or crop insurance, whatever the case might be, and you get into court and you've lost in the administrative agency process, and so now you finally get to a court, and the court's review standard is whether the agency was just completely out of bounds. If what they did was reasonable in any way, the agency wins. And that makes it real tough on farmers and ranchers and others that challenge those decisions by administrative agencies. I think the court is going to back away from that and make it easier to challenge administrative agency decisions.
And Roger, this is an ag law update, and so what implications does this have for agriculture?
Well, this really solidifies the National Water Protection Rule of 2019 that was promulgated in the Trump administration. And that rule limited federal jurisdiction to traditional navigable waters and their tributaries. And so what it means is that now streams and ditches and private waters, such as a farm pond, that don't have a continuous surface connection to navigable waters won't be subject to the Clean Water Act. And so it eliminates federal control over ditches and streams and private ponds where there's no continuous flow into a navigable water of the United States. It's a big deal, particularly you get out into western Kansas. You have all of these ephemeral streams that sometimes have water in it, sometimes don't. Those jurisdiction by the federal government is eliminated over those. Plus in the prairie pothole region in Minnesota and the Dakotas and parts of Iowa, those just are temporary isolated wetlands, and those won't be subject to Clean Water Act jurisdiction either.
And Roger, continuing the conversation about water, what impact does it have on water quality?
I think little to none, for a couple of reasons. One, based on this continuous surface connection and the difference between terminology in the statutes, you could still have a wetland that's not subject to jurisdiction in the Sackett sense, but still be subject to the dredge and fill permit requirements of the Clean Water Act, which are the water quality rules. And those are two different things. Another point is that many states, in fact all states, have water quality rules that are in place, and they're not affected at all by the Supreme Court's opinion. It only affects federal law. So those state rules are still there farmers and ranchers, other landowners are going to have to pay attention to those state water quality rules too. So I think very little to no impact on water quality.
Roger, thank you for joining us today and giving us an ag law update. I appreciate it.
Thank you, Shelby.
That was Roger McEowen, K-State and Washburn law professor, discussing the Supreme Court ruling on the Sackett versus EPA case and what it means for the waters of the U.S. You can find more material from Roger on his blog, which you can find at washburnlaw.edu/Walter. He also has information that you can be found on agmanager.info. Both of the links to those websites can be found in today's show notes on agtoday.net.